My name is Leah Litman. I'm a professor at the University of Michigan Law School. Go Blue. I also co-host Strict Scrutiny, a podcast about the Supreme Court, and I'm the author of Lawless: How the Supreme Court Runs on Conservative Grievance, Fringe Theories, and Bad Vibes. So I thought I would take a little time just to explain the subtitle of the book. I'll start with the bad vibes part. By bad vibes, I mean the court is drawing more on feelings and political talking points than they are on what people would consider law. I'll just take a few examples. So, when the Supreme Court said President Joe Biden could not cancel students' debt relief, they suggested they would not apply their usual rules about how to interpret statutes because student debt relief raised issues that were, quote, personal and emotionally charged. Basically, because a group of people had a lot of feelings and were very agitated about student debt relief, that allowed the court to place a thumb on the scale against student debt relief and to conclude the statute didn't allow it. There are other examples like that from constitutional law. So when the Supreme Court overruled Roe versus Wade, for example, they suggested they weren't required to apply the doctrine of stare decisis, which is respect for precedent, because they said Americans continue to have deeply divided views over abortion. So once again, they are relying on people's feelings and the talking points of a political party in order to decide whether a certain legal rule applies or not. So that's kind of what I mean by vibes. There are also examples where they are drawing more specifically from political talking points. So when the Supreme Court invalidated a key part of the Voting Rights Act, the pre-clearance process, which had required certain states, those with especially bad histories of racial discrimination, to get permission from the federal government before changing their voting laws or policies. The court said that provision was unconstitutional because it subjected the states to disparate treatment and punished the South for its history of racial discrimination. Well, guess who also argued the Voting Rights Act unfairly or unconstitutionally punished the South? The segregationists like Strom Thurmond, who had opposed the Voting Rights Act when it was initially enacted in the 1960s. So that's an example of the court just kind of laundering some political talking points and making them into constitutional law. So, another part of the subtitle is conservative grievance. And this is what I think is really the big vibe, or at least a big vibe that is uniting many different areas of law. What do I mean by conservative grievance? Really, I mean that the justices seem to be of the view that reactionary right-wing Republicans are the victims today. They are the victims of a society that doesn't share their views. They are the victims of laws they disagree with. And because of that, the Republican justices seem to think they are entitled to judicial protection as a minority, and they are entitled to exemptions from various laws they disagree with. So just to take one example, I think the area of LGBT equality and the First Amendment is maybe the clearest example of this. In that context, the Supreme Court has said it's actually unconstitutional to apply some civil rights protections for the LGBT community to individuals or entities who have objections to same-sex marriage or to civil rights for the LGBT community. Why is it unconstitutional to apply those laws to them? Well, because they are minorities whose views are very unpopular and therefore in need of protection. That's actually some of the reasoning that the justices have suggested for why individuals with objections to marriage equality and LGBT equality are entitled constitutionally to exempt themselves from civil rights protections for the LGBT community. And it's that idea of conservative grievance that I identify in many different areas of law throughout the book, from reproductive freedom to LGBT equality to voting rights to the law on campaign finance regulation and political corruption, as well as the law on what administrative agencies can do. So that's the conservative grievance element of the subtitle. The last part is the fringe theories. And by fringe theories, what I mean is the Republican justices are really catering to an increasingly narrow segment of the country, and they are adopting views that are held by an increasingly narrow minority of the country. Just take one fringe theory that they adopted when they were deciding if presidents are immune from criminal prosecution. In that case, the justices reached a conclusion that presidents basically cannot generally be prosecuted for actions they take pursuant to their official duties that a majority, and indeed really a supermajority of the country disagrees with. America as a country was founded on the idea that we don't have kings and that our rulers are not above the law. And the idea that the court would embrace such a theory is just one example of the kind of fringe theories that I think the justices are trafficking in. So that's the basic gist of what I'm trying to convey in my book. There's a lot of pop culture references and snark in there. I hope you check it out. I had a lot of fun writing it, and I hope you enjoy reading it.